On Radio 97, Talking Law is the program you're listening to. And if you have a question to do with the law, then Despina happy to answer that for you. Just pop it to us just pop it to us. You can send it through the website radio97.com.au.
Alrighty, this one's a bit heavy, Despina. You've chosen it for a good reason. Who gets control of your estate when you die without a will? You've had a client come to you recently with this question, and we are covering Queensland and New South Wales. So, Despina, who gets control?
Yeah, it's a big one. Let's just say if you die without a will, there are problems galore. Apart from the obvious that you don't have a will that says how your estate is to be distributed. So apart from the obvious problem, then you actually don't have anyone that is appointed to administer your estate. So people don't think about that. When they go and make a will, everyone has to appoint an executor in the will that they make. So naturally, if you die without a will, not only do you not have a document that says, well, this is how my estate is to be distributed, you also don't have a document that says this is the person or persons who have the authority to administer my estate. And that's very, very important. Now, for that reason alone, everyone over the age of 18 should have a will. I've said that before. Absolutely. You shouldn't think about the value of what you own, which is the standard for whether I do a will or not. Okay, so once you reach 18, definitely do a will, do a power of attorney as well, if you ever lose capacity, so someone can assist you in your affairs. But look, there are problems because what will happen then if you die without a will, someone in your family, and there's an order of priority set in the legislation in each state, someone then has to trundle off to the Supreme Court to make an application to become the administrator. So same role as an executor, but because there's no will with a named executor, they're called administrator. And that person then gets the authority of the court, presuming that their application is successful, to then become the administrator to administer the estate. So basically you have to go to court to get the court stamp of approval to then go and do what you need to do in relation to that deceased estate. Now, as I said, there's an order of priority, right? Both Queensland and New South Wales, and I dare say in every other state and territory in Australia. So let's go through the order of priority because it may not be the person or persons that you really want to have administer your estate. Okay, so you want to think about these things. So in Queensland, in actual fact, when I looked at the New South Wales legislation, Queensland and New South Wales are basically identical.
Okay.
So what I'm going to reel off now is essentially applies to both states. So here's the rule is set out for Queensland and New South Wales. So the order is your spouse. Okay, so that makes sense. Yep. So your spouse can make the application if your spouse isn't around your children. Now, it gets a bit interesting when you have more than one child. They equally have the same entitlement, but maybe you've got one child that doesn't want to do it. Maybe someone can't be found. Maybe someone's vulnerable, they shouldn't be making that application. So then that creates an added layer of complication of, well, who amongst the children are going to make the application? Is it a joint application or do we have to remove someone? And then you've got to go through that process. So if there are no children, then you look at grandchildren or great-grandchildren. Then you have to go to parents, brothers and sisters, nieces and nephews, grandparent, uncles and aunts, and first cousins. So you basically cover everybody in your family circle, but that's the order of priority that someone can make that application.
Wow. So if you had someone that, say, was a carer and very involved with someone's life and they thought, yep, no will, but they put their hand up and volunteered to, take it on board and make those decisions. If everyone happened to agree, would you still have to go through that whole process, that court process together?
The court still has to be confident and has to have everybody ticked off in that a list of priorities in the order. They have to be basically ticked off to say, okay, you don't want to be it, you don't want to be it, you don't want to apply. So if someone not in that list wants to make the application, it doesn't mean that they can't, but what it does mean is a very long and arduous process of basically kicking everybody off the list because those people don't want to make it, and that'd be pretty rare. That'd be pretty rare. So they've got to go through that entire process, and that might take a long time. What if someone's passed away? Then you've got to get the evidence that they've died. You've got to apply for their death certificate. So we've been through that quite a few times, and we've had several people in that list already had passed away. So you're going to go through that process of getting evidence that they actually died, to then be able and be eligible to make the application. So yeah, it's not a pleasant thing. It has to be done because you can't just have anybody go and access assets. So if you went to a bank after someone's died and said, look, this person's died, there's 50 grand in the bank, I'm the next of kin, quote unquote, the bank's not going to just let you close the account and take the money. You've got no authority if there's no will, that you're not the appointed executor, and there's no grant from the Supreme Court to say you're the administrator that has the authority to administer the estate. So it's more time involved and more costly. Yeah.
Yeah.
So you can deal with that with just making a will.
What about, just really briefly, and there would be some, perhaps not that many, people who you go through that list that you just talked about, and for one reason or another, there is just no one there. What happens then if you exhaust all of those possibilities? Where does the court go then?
Yeah, so the public trustee would have to be approached to be able to do that. Yeah, and there obviously would be somebody, right, that would have to make that noise to the public trustee to be able to do that. So there must be someone looking around. There may not be family. There might be a friend or someone. Yes. But maybe they would be eligible with the right grounds. But, again, it's not, probably not. So there are strict rules in place by the Supreme Court as to who is eligible. So as I said, you can dispense with all of that by making a will and appointing people to be the executor, and always have backups. Not just one person. You're going to have the second or a third. You can have up to 4 executors acting jointly if you want to. So, yeah, that's one main reason to have a will, naturally. The second obvious reason is if you die without a will, well, the intestacy rules govern how your estate is distributed. And each state is different as to what those intestacy rules say. So basically, if you die without a will, you're saying, well, the legislation will dictate what happens to my estate, and that may very well not be what you want. Okay, so what we'll do very quickly is talk about the intestacy rules. So in Queensland, it'll always depend, like New South Wales, if you die with a spouse or without a spouse. So if you die and you leave a spouse and you don't have children at all, right, stepchildren, adopted children in Queensland, everything goes to the spouse, right? Easy peasy. But it's not always easy peasy, because you could have, multiple people in your family. You could have blended families. So if you die with children, then there's a certain formula set in Queensland. So the spouse gets 150,000, which is pretty low, and that hasn't been changed in years, actually, by the legislation. They get all the household chattels, and they get a part of the balance of the estate depending on how many children. So if there's more than one child, they might get a third. If there's only one child, they'll get half. So it depends on how many children. If there's no spouse and there's children, the children just receive the entire estate together. And if there's no children and no spouse, then you deal with an order again, right? So you've got parents, brothers and sisters, grandparents, aunts and uncles, right? So again, an order of priority set by the legislation, which is not necessarily what you want to have happen after you pass away. Okay. In New South Wales, a little bit different. Again, you've got the spouse and children that starts off. So if you have a spouse, the spouse gets, and the spouse survives you, they get their personal effects. They get a statutory legacy of $482,000, which is adjusted by CPI each year. Right, so that was the figure in 2020, and then they get part of the residue, whatever's left over. If there's no spouse, again, the children inherit in equal shares. If there's no spouse and no children, right, then you've got this order again, and it's basically the same as Queensland. But it does stipulate there that if you have no parents, no brothers and sisters, no grandparents, no aunts and uncles, no first cousins, then it does say that the New South Wales government gets it.
Oh, okay. You don't want that. You definitely
if
don't
you'd
want
rather
that.
cousin Jerry to get all your money
Yeah.
rather than the government, make your will. Thank you so much, Justina. If anyone does want to get in touch with you directly about getting their will done or any other legal question, where can they go?
So they can phone the office, 55291 294, email info@priellalegal.com.au, and this will be up on YouTube end of the week.
Thank you so much.
Are you
Christina and Ray.
And we'll
confused
see you
about
next
legal
week.
jargon?
See you
Do
then.
you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.